now we're going to talk about modifying child custody orders and enforcing child custody orders. So these are the situations either in the middle tier or the bottom tier on the last graph or last whiteboard. So it's not informal, it's formal. We have an order with court setting out, let's say, primary custody with mom and dad has reasonable visitation. Remember, that's not overnight. So modification is when we change that custody order. It is still held to the same standard. The best interests of the child. So when the best interests of the child change, custody can change. We're still going to look at the same factors. We're going to do the same analysis. But modifications are still in the best interest of the child, that same standard. Because circumstances change. Parents go to prison, parents get remarried, parents get redivorced, parents get all kinds of things change in the lives of children that are under the influence of the court. However, this is another situation where parents can be motivated improperly and decide to take their ex back to court every 3 months because they want to prove that things have changed. And it's a revolving door of non-justice because their real motivation is making the other person pay more in attorney's fees and they just want to take them to court. Or they think the best interest has changed over something like cutting the child's hair improperly, or maybe the custodial parent had a new baby and they think that they should no longer have custody because they're doting on the infant too much. Okay. Modifications, because they have because we favor stability. So one of the things that is pretty common is that courts and even statutes talk about the fact that stability is almost always in the best interest of the child. So we are not going to allow a court to hear a modification on the whim of the parties. And so there are always time limits. In Kentucky, if you want to modify custody from an initial agreement filed with the court or an initial court finding, you have to wait 2 years to modify custody. In Indiana, modifications can only be you can only file for modification once a year. There are exceptions to that. Primarily, if a child is in a situation where their health or safety is being impacted. So let's say the court order was just put in place and within 3 months mom has picked up an addiction to pain pills and now she's not watching the kid. So the kid's safety is compromised. That's a situation where the court can look at it before those initial 2 years. That time limit's different from state to state, and this is just for the initial hearing in Kentucky. Or the custodial parent has flown the coop and a de facto custodian is now taking care of the kid. And so there's a court order signed, and within 6 months, dad has given the kid spends most of his time with dad's parents, his grandparents, and not the father. And so he doesn't have, isn't exercising that custody. We're going to have the time limit, but we'll always have exceptions for the health and safety of the child, and you have to, without those, you have to wait the statutory time frame before you can seek a modification, whether it's of an initial or a subsequent order. There's going to be a time frame that applies. Enforcement. If we are in court, then the custody of a child is a court order. Well, what are the typical sanctions for violating a court order? They're exactly the same in family court as they are in civil court. Except the sanctions take a little bit, they have a different flavor. So people who violate court orders can be held in contempt of court. And even for civil infractions, civil contempt, they can be jailed. they can lose custody. So the court can modify the order. If they keep breaking it, they can modify it to reduce their custody. That's the sanction. Because what you win in a family law case is the custody of a child. What you win in a civil case is money. So we're going to take both of those away from you if you violate a court order. So both of those can be enforced by the court. The other way that court orders can be enforced is with the police. So police can help enforce court orders. If you have an order saying, I have custody, I have a court order giving me custody, police officers may enforce it. They may not, but they may. Without a court order, the police aren't going to do anything. The police aren't going to want to get involved. And this is one area where I have to give you a word of warning. Police often, getting the police involved in a child custody dispute is almost always the wrong thing to do. Granted, there are situations of danger where stuff happens. I get it, it does. But the police, by and large, have no business being involved in family disputes. Does that mean they don't get called? No, of course not. But it is an area where police officers very often get called in all the time. They do not want to deal with it and are poorly equipped to deal with it. If there is one aspect of the law that police officers, generally speaking, do not know, it's family law. And that's okay, because that's not their job. Police officers, it is not their job to be a family court, and they'll tell you that. So sometimes, yes, police can enforce court orders, but it's a last resort type thing. And it is not their job, nor should it be, to be within the purview of family court. But that is some level of enforcement. In a subsequent lecture, we will talk about state-to-state enforcement. I'm going to give you a little nugget right now. So this is about jurisdiction, and we have these nationwide acts about uniform enforcement. Just like it used to be possible to bring someone to court every 3 months to change custody or support. Same thing happens with support, which we'll get to in a little bit. It used to be possible to just hop across state lines and file a new custody case. So if I roll the dice here in Indiana and I lose, I'm going to hop over to Kentucky. I'm going to file it in Kentucky. It used to be that we could modify by modifying frequently, or I can forum shop. And largely, the enforcement of a court order is going to be streamlined state to state because of the UCCJA, Uniform Child Custody Jurisdiction Act, or Jurisdiction and Enforcement Act, the UCCJEA, which we'll talk about more in depth later. But enforcement, generally speaking, we're going to give a full faith and credit to a custody order issued by a state. So if I have a custody order that I don't like in Indiana and I go to Kentucky, Kentucky is going to enforce the Indiana order. And Kentucky is probably going to, unless something happens, push me back to Indiana to modify it. So we can't forum shop in that way either. So child custody, typically in terms of jurisdiction, is where the child lives, where the parties live, and so look at the statutes in terms of where we file child custody cases as well in terms of the logistics of this. Okay. One other thing that I wanted to talk about. Okay, so what if we have changed circumstances? So if it's a health or safety issue, yeah, we can modify right away. Let's say it's not. I'm still going to look at the same standard, the best interest of the child. But in terms of a modification, again, look at your state statute. But we're going to change custody when there is a reason to change custody. And we'll look at the statutes for modification as well. But let's say it's not a dangerous situation. We've waited the statutory period of time, and now we want to file to modify custody. There are some fairly common times when that happens. One might be mom gets a much better job, and so now she's making more money, and it's been a couple of years and she wants to fight for more custody because let's say she's the mom in the unstable place, but let's say she gets a home and she's in that home for 2 years and now she has a good job. If I'm representing her, I will file on day one. I think she should have had custody to begin with because she was the primary caretaker. But if she can prove stability, that's the reason in the Daae case that she didn't get custody. So I'm gonna say that that's a changed circumstance. She's been stable. She did what you wanted her to do. She needs more custody. Relocation. People relocate for all different reasons. Maybe they relocate for a new job. Maybe they relocate because they would like to move to Canada. That may not be a good reason to change custody. I have decided that the love of my life that I met on Tinder is Canadian, and I want to move to be with him in Canada, and I want the court to modify custody so that I can take my child to Canada. Good luck. That's very unlikely to happen. But if I want to move to Kentucky because I got a better job in Kentucky and I want to put my kid in a magnet school in Kentucky, maybe that's something that the court's going to look at in the best interest of the child. But if it's I want to relocate to get remarried, that is not necessarily in the best interest of the child unless they have an established good relationship with that step parent in waiting. But the court can look at those things. Prison or incarceration. So a person who's a parent who's been imprisoned, that's not abusive to the child. But if they can't physically take care of the child, then that may be a reason to modify. Certainly abuse or mistreatment, if it doesn't rise to the level of abuse, giving us the right to modify immediately. And then we look at the needs of the child. What a 5-year-old needs is not the same thing as what a 14-year-old needs. I've never been that strict of a parent with my child as a very young child. When he is 14, I fear what our relationship is going to be like, because I can see myself being far stricter on a teenager, because in my mind the consequences are more vast than a 3-year-old who acts out. But what that child needs may change over the years, and maybe he needs more supervision, maybe he needs less supervision. Maybe he's a kid who thrives making their own decisions and they're really independent and they make good decisions and all of that. So the needs of the child can change over time. And the death of a parent, the death of a grandparent, or the relationship with grandparents, all of these are things that can modify custody. But again, we're still going to look at the best interest of the child. We're going to look at what the best interests of the child are under changed circumstances. And again, we're going to have those time limits that come into play. Okay, so that is child custody in a nutshell. I'm not going to get too much into domestic violence and alienation because we're going to talk about domestic violence in a later unit, but know that they do impact custody, and they impact custody far greater than they impact criminal cases. So if you don't know much about domestic violence and how it's prosecuted criminally, domestic violence includes abuse of parents towards each other, even if they were never married. And it includes child abuse, and it includes abuse of a partner in front of a child. In fact, in many states that will elevate the level of offense. But domestic violence is treated by the court system both less stringently than regular assault and more stringently. So most states allow for diversion, which means the first time you get arrested for domestic violence, you can make sure that it doesn't stick on your record if you do some things and are, go do what the court asks of you and stay out of trouble. On the other hand, if you commit felony level or sometimes worse abuse comes with mandatory jail time, and so we do treat it both less severely and more severely. But there are plenty of situations that do not rise to the level of criminal charges or DCS involvement that a court can take into consideration when determining custody in terms of domestic violence and abuse. So we look at yelling, we look at corporal punishment and how good or bad that is for an individual child. We look at alienation. So the concept of alienation is when kid is with mom and mom says bad things about dad, and that's not okay. The court can take that into consideration when determining custody arrangements as well, and so that's another aspect to be aware of. Okay, that's it for part 3 of child custody.